Thank you, Madam Clerk. So we are here for the 245 session of the Court of Criminal Appeals. First, based on the COVID situation, we are taking special measures. Counsel, I'm sure you have been told you stand or sit for your argument. You do not have to wear your mask when you're arguing. But make sure, we had this the last time, 2 times, make sure your microphone's on, because we are recording this and broadcasting this for those on YouTube. And so we want to make sure people have access. And with that, I would want to introduce the court. To my left and your right is our presiding judge, John Everett Williams from Carroll County. He's responsible for the fact that we are here as a court today and person and live instead of over Zoom and staring at each other over computer screens. He's also the reason that I have the privilege of sitting in the middle today and presiding, though I am the most junior member of the court. And I want to thank him and appreciate him for his leadership and his friendship. And then to my right, your left is Judge Camille McMullen from Shelby County, my office mate and friend. And then I am Ross Dyer from Shelby County as well. And with that, oh, and if you would like to reserve any time for rebuttal, please let me know at the beginning. With that, Madam Clerk, will you please call the case?
May it please the court, my name is Glover Wright, and I'm here today from the law office of the Shelby County Public Defender in Memphis. It's my privilege today to be here representing Yolanda Tucker. I do want the court to know that Ms. Tucker lives in northern Mississippi, and she would be here today if she could. She does not have reliable transportation to get her here, but my understanding is she is watching via YouTube. And so I wanted to thank the court for allowing her that opportunity. I would like to reserve 4 minutes, please, for rebuttal. This appeal is about whether Yolanda Tucker should get diversion, and so I want to begin just briefly by telling you about who she is, and then briefly discuss the facts that got us to this point, both for the benefit of the court as well as anyone who may be trying to follow along. Yolanda Tucker is a 45-year-old woman who was born with an intellectual disability and who suffers to this day from a number of serious medical issues. These medical issues include bad eyesight, an iron deficiency, anemia, weakened bones, torn ligaments in both of her knees, arthritis, low calcium, and recurring migraines. Since 1992, she has drawn disability from Social Security. Her diagnosis from Social Security confirms that she has significant sub-average general intellectual function and that she depends upon others to help meet her personal needs. She graduated high school in 1993, but received a certificate, not a diploma. The case before this court stemmed from an incident in July of 2016 when Ms. Tucker stabbed Shawnee Davis with a pocket knife provided to her by her co-defendant, Albert Jackson. Mr. Jackson, like Ms. Tucker, entered a guilty plea following this incident to aggravated assault. What the trial court heard at sentencing was that Ms. Tucker and Mr. Jackson were girlfriend and boyfriend, and that Mr. Jackson and Ms. Davis were cousins. Before the stabbing, Ms. Tucker had been with Mr. Jackson and Ms. Davis and a number of their family members at a hospital in Memphis. They were at this hospital because Ms. Davis's mother was being treated there until she passed away shortly, just hours before the stabbing. After Ms. Davis's mother passed away, Ms. Davis gave Ms. Tucker and Mr. Jackson a ride from the hospital to an impromptu wake, but stopped along the way at a drive-thru for food. At some point during that ride, Ms. Davis accused Ms. Tucker, and Mr. Jackson of stealing money from her work bag in the car, and Mr. Jackson in particular of vomiting in her car. Now, after these accusations, all three got into an argument about what had or had not happened, which continued when they arrived at the wake. Ms. Davis was aggressive enough that several family members held her back from physically fighting with Ms. Tucker. Unfortunately, Ms. Davis and Ms. Tucker did get into a physical fight, and during that fight, Mr. Jackson handed Ms. Tucker the pocket knife with which she stabbed Ms. Davis. Ms. Davis suffered significant injuries. The trial court heard and denied Ms. Tucker's petition for diversion on July 25th of 2019, the same day she entered a guilty plea to aggravated assault, and that was more than 3 years after the stabbing. As to why we are here today, we submit that the trial court erred twice in this case at sentencing, and that both errors require this court's reversing the trial court and ordering the diversion be granted in this case. I'll take them step by step. The trial court's first error was that it denied Ms. Tucker her statutory right to allocution. At the beginning of the sentencing hearing, the defense counsel informed the trial court that due to Ms. Tucker's unique circumstances, Ms. Tucker would not testify as a witness, but had prepared an allocution to read to the trial court. Now, the trial court's unequivocal ruling at that point was, and this is a quote from page 13 of the sentencing hearing transcript, "She is going to have to testify if she is going to apply for diversion." The trial court then heard testimony from Ms. Tucker, who underwent rigorous cross-examination before denying diversion. This court, Court of Criminal Appeals, held in State v. Keithley that a trial court may not rely upon a defendant's sworn testimony, subject moreover to rigorous cross-examination, in fashioning her sentence after denying the defendant her right to allocution. To do so is to commit plain error and requires reversal. I would like to clarify one point from my brief. I use the term plain error in my brief, and I use the term here because that is the term that this court used in reaching its conclusion in Keithley. Even though that opinion does not explicitly undertake what we might expect from a so-called plain error analysis, I don't believe that this court today needs to apply a traditional plain error analysis in order to reverse. I think this issue was adequately preserved by Ms. Tucker's clear invocation of her statutory right to allocution and the trial court's clear denial of that right. But I use that term because Keithley is the case that we believe is most directly on point. That said, even if the court were to undertake a traditional plain error analysis, I think that those 5 factors would still require the same conclusion, which is that reversal is warranted. I also want to acknowledge that it's true that this court said in Keithley that reversible error may not always occur when a defendant is placed under oath and subjected to cross-examination. But just like in Keithley, the trial court's error was not harmless with Ms. Tucker. It wasn't harmless because just like in Keithley, the trial court relied upon what happened in the course of Ms. Tucker's testimony in denying diversion. And we know that. We know the trial court relied upon what happened during Ms. Tucker's testimony in denying diversion because it explicitly said, in considering whether diversion would serve the interest of the public as well as Ms. Tucker, and this is again a quote from the transcript, "I did witness her on the stand today to show anger directed at the prosecutor because of his questions. I do think judicial diversion being denied here will serve the interest of the public." That is at pages 71 and 72 of the sentencing hearing transcript. This court found such reliance upon a defendant's testimony inappropriate in Keithley, and it is no less inappropriate here with Ms. Tucker. Now, the state in its reply brief, I'm sorry.
If she is quick to anger, that's not anything that the judge can consider?
Your Honor, I think that that could be something the judge could consider. And I think that the record indicates that Ms. Tucker did have an anger problem. I think that's something that everyone would stipulate to. But what the judge based her ruling on explicitly in that quote is what the judge witnessed on the witness stand from Ms. Tucker in the course of cross-examination. And when the court explicitly ties its ruling to witnessing that specific conduct on the witness stand, conduct that the court would not have witnessed had Ms. Tucker not been made to take the stand in order to ask for diversion, had not been subjected to cross-examination, then the court would not have that basis to make its ruling on. And so I think that, yes, the court can consider that. It would be appropriate, but not the way the court did in this case.
So if they'd allowed an allocution, the defendant would have sat down and not testified?
Yes, Your Honor.
So the judge couldn't ask her any questions about what she said on the allocution?
Yes, Your Honor. Per her statutory right of allocution, she would have read an unsworn statement into the record, and that is all the judge would have to base the judge's decision on with respect to the defendant that day in court. She would not have been called to the stand. She would not have been cross-examined. She would not have been asked questions by the court.
What would the allocution, how much weight could the allocution be given?
Well, Your Honor, I think that per the statute, the defendant is entitled to allocute, and that is a factor for the court to consider in sentencing. And so I think how much weight is to be given to the allocution, that's a matter for the trial court's discretion. That would be a credibility determination in some ways for the trial court. But we know what Ms. Tucker wanted to allocute to, because she did in fact read that statement to the court. And it was a short statement prepared on the back of a white paper bag that is in fact in the record for this court to see. And in that, she expresses clear regret and clear remorse. And insofar as she did testify to that, certainly the trial court had no credibility problems with that. And so I think that, that forcing Ms. Tucker to take the stand, subjecting her to cross-examination, based on the record that we have, that is what the court looked at in making this decision, and we think that was inappropriate. I do want to briefly mention that the state attempts to distinguish Keithley from this case because in Keithley, the defendant did not answer any questions on direct examination, whereas Ms. Tucker did. But this is a distinction I would submit without a difference. A statement read by a defendant subject to cross-examination is essentially the same as direct examination testimony. And moreover, just like in Keithley, Ms. Tucker was subjected to rigorous cross-examination by the prosecutor as well as questioning by the trial court. And again, just like in Keithley, the trial court relied upon that testimony in fashioning a sentence. And so with respect to that first error in denying allocution, we are submitting that this court should find error and should reverse the trial court's denial of diversion. The question that would be remaining is what exactly this court should do in the event that it does in fact find that the trial court erred in denying allocution. And to answer that, I'd like to turn as well to the second question in our brief, and the second issue, which is that we believe the trial court erred in failing to provide an adequate reason for denying diversion. In its reply brief, the state says that Ms. Tucker complains that the court made no findings as to the relevant weights it was giving each factor, or why any factor was given more weight than any other, but that she failed to provide any authority showing that such mathematical formulation is required to be placed on the record, and that, to the contrary, our Supreme Court only requires the court to explain on the record why it is making that decision. And the state is absolutely right about our complaint, but I would submit that the state elides what exactly our Supreme Court has said in Tennessee. We are not saying that there must be any mechanical numerical formulation to which the trial court must adhere, but we are saying that in State v. King, the Tennessee Supreme Court clearly stated that where the trial court, quote, fails to consider and weigh the applicable electroplating and Parker factors, the presumption of reasonableness does not apply, and the abuse of discretion standard is not appropriate. And that word, weigh, must mean something other than consider. Otherwise, it would not follow the conjunction and. And where there is no weighing, this court may either conduct a de novo review or remand the issue for reconsideration. And so the question then is, what did the trial court in this case consider and what did it weigh? And here I'd like to talk about four things. The trial court did not make any clear finding as to Ms. Tucker's amenability to correction. In fact, it said she hoped she was amenable to correction, but didn't know. And that is, excuse me, that's on page 70 of the transcript. In considering the factor, considering the deterrence value to Ms. Tucker and the public, the trial court stated only that Ms. Tucker, quote, needs to be deterred as well as for others, as well as for Ms. Tucker. As this court said just last year in State v. Hatfield, these findings with regard to deterrence were, and this is a quote from this court in that case, less than coherent. They were less than coherent for Ms. Tucker because the Tennessee Supreme Court has held in State v. Hooper that the need for deterrence will support the denial of diversion only, quote, when the record contains evidence which would enable a reasonable person to conclude that, number one, deterrence is needed in the community, and number two, the defendant's incarceration may rationally serve as a deterrent to others similarly situated and likely to commit similar crimes. The record does not contain any such evidence in this case, and in fact, the trial court found incarceration completely unnecessary. Number three, the trial court found the circumstances of this offense were extremely bad. But while the trial court did not say that it was denying diversion based solely on the seriousness of the offense, the Tennessee Supreme Court has held in State v. Trotter that the seriousness of the offense may serve as the sole basis for denying diversion only when the circumstances of the offense are especially violent, horrifying, shocking, reprehensible, offensive, or otherwise of an excessive or exaggerated degree, and the nature of the offense must outweigh all factors favoring a sentence other than confinement. And again, there we have this idea of weighing. That's something that the trial court must do, and in order to evaluate what the trial court is weighing, the trial court must explain, must articulate what is being weighed and what weight is being given. The trial court made no such finding here with respect to the circumstances of the offense because it did not articulate what factors, if any, outweighed any or all others. I'd also note that as this court found in State v. Lacey, the facts of the case, while unsettling, were already incorporated into the conviction offense of aggravated assault. And perhaps more importantly, the trial court explicitly found in mitigation that there was some, quote, strong provocation by the victim in this case. And that finding that there was some strong provocation is on page 68 of the sentencing hearing transcript. Finally, number 4, the trial court did not really even consider, much less weigh, whether diversion would serve the interest of the public as well as Ms. Tucker. In fact, the trial court discounted any interest of Ms. Tucker in being granted diversion, stating, quote, "I don't see any reason why Ms. Tucker has to have judicial diversion. She is not employed. That will not prevent her from obtaining employment. She is basically unemployable." That's at page 72 of the sentencing hearing transcript, and that is the only consideration on the record of whether Ms. Tucker had an interest in judicial diversion. And so in short, I submit to this court today that the trial court failed to weigh the required factors other than in a conclusory manner. The trial court failed to provide an adequate reason for denying diversion, and because of that, its decision is entitled to no deference. This court should therefore apply its power of de novo review to remedy the trial court's wrong and to order that Ms. Tucker be granted diversion.
Don't you think, though, at the end of the day, the trial court, who has seen the witnesses, talked to the witnesses, is in better position to make those determinations than we are?
Your Honor, when I'm thinking about what remedy to ask for from this court, obviously we think that the trial court committed these 2 errors. And so my question then is, what remedy do I ask for from this court if this court would be inclined to agree with me on one or both of those? And in that, I'm guided by what this court found in Keithley, which was when this court reversed the trial court's denial of diversion, it remanded for transfer to another judge, given what this court called the prejudicial nature of the information elicited by the state and by the trial judge. And so just like in Keithley, which again I would submit is extremely similar to this case, and I think that is controlling here, should this court find error, I believe that no matter what happens, the case should be assigned to another judge because of the prejudicial nature of that information that the trial court elicited when Ms. Tucker had to take the stand. I think in general, yes, a trial court is best positioned to consider a record and to weigh those factors. However, I think that we have, with respect to Ms. Tucker, a very compelling record. There is a pre-sentence report that she participated in. There is a sentencing memorandum. There is testimony. There are findings by the trial court that would weigh heavily in favor of Ms. Tucker getting diversion. The trial court simply did not articulate what weight it was or was not giving. And so we think that should this court find error, it would be well within reason for this court to consider that developed record and to grant diversion.
Well, so if we just think that the trial judge didn't articulate her weight and how she, then if that's the only error we find, don't you, obviously, then we have to send it back to this trial judge, correct?
I again would look to Keithley, and I would say it's my position that Keithley is controlling, and Keithley says it's plain error for a trial court to deny allocution. And Keithley also says that the error may sometimes be harmless. And obviously, we're submitting this was not harmless error. However, taking the position that it is error for a judge to deny allocution and then to proceed with sentencing based on what comes out after that denial, even if that error is harmless, that trial court has been exposed to what this court has found to be prejudicial information. And so I think that the honest answer to your question is if this court chose not to exercise its power of de novo review, then what the law suggests should happen is that the case be remanded and transferred to another judge. However, again, I would submit that the record is well developed enough for this court on de novo review simply to find that diversion is appropriate in this very particular case.
Okay.
And with that, I would rest for now.
All right. Thank you.
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. I think it's important to clarify exactly what the first issue that has been raised here. The claim is that the trial court precluded the defendant from allocuting, and that is simply not the case here. The defendant was allowed to allocute. She was allowed to read her statement uninterrupted. That statement was then admitted as an exhibit at the sentencing hearing, and the trial court clearly took notes on it. So we have an allocution. And before you get to Keithley or any other of these cases that we talk about, you have to have the denial of the right to allocute. Because that didn't happen here, there is no issue. But even if this court were to determine that the trial court's commentary about its inclination to grant diversion being based on or being precipitated on the defendant's testimony, in addition to, if this court were to instead determine that that was a comment saying in lieu of her allocution.
Well, how do you interpret?
So to provide some context, what the defendant had said right before that comment was we're still trying to figure out whether we want her to testify. And we think we're going to have her allocute and that her sister is going to testify.
So this wasn't the trial court saying, in order for me to consider diversion, you're going to have to take the witness stand?
I think it was the trial court providing a guideline or a roadmap for how the defendant would be most likely to get judicial diversion.
Is that proper?
That is not the issue on appeal, Your Honor. The explicit issue on appeal is whether she was denied her right to allocute. And she wasn't. Again, she was allowed to read her statement. It was admitted as an exhibit, and it went into, and the trial court considered it. So to the extent that any other issue has been tangentially applied, it's been waived because there's been no law on it. There's been nothing. This all applies to when the defendant is denied the right to allocute. And again, it's very important to point out, she was not denied her right to allocute. So
Was she forced to testify?
I wouldn't categorize it as forced, Your Honor. I don't think there was any infringement of her constitutional right to remain silent or anything. Again, I think the trial court was commenting that for me to be, the trial court was saying, I am currently disinclined to grant judicial diversion. And if you want to prove your burden of establishing your reasonableness for judicial diversion, you're going to have to convince me and do that by testifying. I don't think that was forcing her to testify.
What else is she going to do? Because the trial judge has announced, you've just allocated, which let's assume it. The trial judge says you've just allocated, and I'm not really thinking I want to give diversion unless you take the stand, get sworn in, and testify. Well, she doesn't take the stand and get sworn in and testify. Pretty clear the trial court's going to deny it. And you kind of alluded to this a second ago. If she takes the stand and pleads the fifth or doesn't really say anything, it's going to get denied. I mean, the only way that she's getting diversion in her mind, based on that statement, is I got to take the stand and testify.
So I think two things, Your Honor. First, it's important to note the timing. This was not after she read her allocution and then the trial court said, that's not enough for me. Instead, this was before she read her allocution. But more importantly, that is a separate issue that she could have raised. And she's not raised that before this court.
Can we reach that issue anyway?
If the defendant hasn't raised it and hasn't even asked this court to do a plain error analysis, the state submits that this court should not do an analysis, but this court certainly can do whatever it wants. But
At least you're honest.
Yes, Your Honor. And it's important to again note that she was allowed to allocute, and as the defendant pointed pointed out, he thinks that, or she thinks that Keithley applies, but it's readily distinguishable. There was an explicit denial of the right to allocute. There was no confusion of, we're not sure whether the defendant is going to testify. We think they're going to do it in addition to. There was no confusion. The defendant said, all I want to do is allocute in Keithley. And the judge says, no, you don't get to do that. You have to get up on the stand. So we've already got, that's where you get the denial. And then you look at whether there is reversible error. But even, again, even if this court were to construe the trial court's language as denying her right to allocute, which the state submits it does not because she then allocated, it was harmless beyond a reasonable doubt. And when you're looking at the factors pointed out by Keithley, again, there is an explicit denial, which was not here. The defendant in Keithley did not testify at all with direct examination. Here, the trial counsel explicitly said, okay, now that we've got your allocution out of the way, let's talk about some other things, and discussed significant information that would go towards the granting or denial of judicial diversion during direct examination. The third factor in Keithley was that there was rigorous cross-examination from the state and trial court, and it was not that rigorous here. Yes, the state cross-examined her. Yes, the trial court asked some clarification, but it was not scathing. It was not as rigorous as in Keithley. And finally, the point in Keithley that the trial court relied primarily on the defendant's testimony that he was essentially forced to give. The trial court almost entirely based its reasoning for denying diversion on that testimony alone. Here, as you pointed out, Judge Williams, the trial court was allowed to consider whether the defendant had anger issues. And in fact, she said that she had anger issues in her allocution. And so to the extent that it relied minutely on her behavior on the stand, it didn't primarily rely on that. And even if when it relied on it, it only relied on it for one of the 7 factors.
That's going to be my next question, and that is, in the trial court's analysis, how much of that information crossed over? So how much of that information that the trial court relied on is in the allocution as well as in the testimony, and how much of it is solely just out of testimony?
To the defendant's detriment, Your Honor, or to her benefit?
Either way.
There was a significant amount that went towards her benefit because she gave significant direct examination testimony about her history, her medical history, her physical history, things of that nature. And the trial court incorporated that when it was considering her physical and mental, her physical and mental health. The only thing that it could be seen as going to her detriment was to the commentary about her attitude towards the prosecutor. And that was towards the deterrent, I believe that was towards the deterrent effect. And it was just that one amount. I don't remember anything else that the trial court specifically referenced based on the defendant's testimony when it was analyzing whether to grant or deny the diversion. So to that first issue, again, the defendant was allowed to allocute. That is the clear-cut answer that she should lose on that issue. But even if this court were to determine that she wasn't allowed to allocute, it's not harmless beyond a reasonable doubt. If there are no further questions on that issue, I'll move to the diversion. The defendant claims that they aren't asking for a mechanical or mathematical formula, but then also argues that a trial court must articulate exactly what weight is being given. Whether or not that's unclear as to what that position is, our Supreme Court has been very clear in King that the trial court does not need to do mathematical formulas, does not even need to go into the specific weights and provide a balanced scale on the record. Instead, they must show that they've considered the factors on the record, that they find certain ones applicable, and then explain their reasoning for why they are granting or denying judicial diversion. And the trial court did so here. The trial court found essentially all 7 of the factors, the Parker and electroplating factors, applicable, and it explained where it fell, if it was favorable to the defendant or favorable towards the denial of judicial diversion. And as the defendant pointed out, the amenability to correction actually kind of came down in the middle. The court said it hoped that she was amenable to correction, but it wasn't sure. So that was kind of a wash. It pointed out that the circumstances of the offense were extremely bad in this case. And it's important to note that Ms. Davis suffered multiple stabbing and slashing wounds in the face, in her throat, and in her chest. She was in the hospital for 3 weeks. She was paralyzed in her right arm, and she lives in constant pain. So the trial court analyzed that and found that because the circumstance of the offense weigh heavily against the granting of diversion. But on the other hand, it found some factors for the defendant. It conceded that the defendant's social history was, quote, very tough, and that she suffered from multiple health issues. But then again, it went back and found that the need for deterrence, that this type of behavior does need to be deterred, and that weighed against the granting of diversion, and that people do need to be warned about the defendant who acted with such anger and seriously injured someone else, such that diversion being denied here will serve the interest of the public. The trial court clearly analyzed all the factors, and even if it didn't explicitly say, I am giving this factor great weight or 50% weight against or granting the denial, against the granting or denial of diversion, it clearly explained why those factors weighed the way they did, and it clearly weighed them when it came to a conclusion. Just a few things that the defendant pointed out. The defendant referenced Hooper and Trotter, and I think it's important to note Hooper, this court has already held Hooper does not apply in judicial diversion. More importantly, even if it does apply, it doesn't apply in this case, because Hooper stands for the proposition that when a trial court denies probation, or if you want to say judicial diversion, solely on the need for deterrence, then you have a heightened standard. And even in our Supreme Court has clarified, and it referenced pretrial diversion instead of judicial diversion, but because of their similarities, the principle applies. And in State v. Hamilton, our Supreme Court said when the prosecutor in that case considered all of the relevant factors, the Hooper standard doesn't apply. So because the court considered all the factors, Hooper doesn't apply. For the same reason, Trotter, which talks about when it's solely based on the circumstances of the offense, that doesn't apply either, because again, trial court considered all of the relevant factors. If there are no further questions, we respectfully ask that you affirm the judgment of the trial court.
If we agree with the defendant, can we send it back to the same trial judge, or do we need to assign a new trial judge?
I think you can send it back to the same trial judge, Your Honor. Even if you wanted to include a footnote to remind the trial court, hey, you can't consider, if this court were to find that it was an error for the defendant to testify, a simple instruction telling the trial court, hey, you should have considered that, don't consider it now, would suffice. And because the court clearly analyzed the factors, it would make sense to send it back down to that trial court and say, put some weight on if you have to give the mathematical formula. Thank you, Your Honors.
You have your 4 minutes.
Thank you, Your Honor. I'd like to be sure that that we all understand what we are talking about when we use the word allocution, or at least what I'm talking about. And in Tennessee, a defendant has a statutory right of allocution. The Tennessee Supreme Court has said that recently. State v. Patterson, it's codified in the Tennessee Code annotated. Allocution is defined as an unsworn statement not subject to cross-examination from a convicted defendant to the sentencing judge. That's the dictionary definition of allocution. In a trial court, our Supreme Court has said, must consider such a statement in determining a defendant's appropriate sentence. So when the state says that Ms. Tucker was allowed to present an allocution, that's simply not true, because Ms. Tucker was required to submit the statement she prepared under oath on the stand. And by definition, a sworn statement under oath is not an allocution. And so I would just like to be clear about that. I want to point out that before Ms. Tucker entered a guilty plea to aggravated assault on the same day as sentencing, she underwent a very thorough mental evaluation that was requested by the defense and ordered by the court. That evaluation concluded that although Ms. Tucker was competent, she is low functioning and would need extra accommodation from her attorney and from the trial court. And those concerns were actually re-emphasized to the trial court immediately before Ms. Tucker's sentencing hearing at a bench conference that was in fact requested by the state. And so when the state suggests today that the cross-examination Ms. Tucker underwent was maybe not so rigorous as that in Keithley, I think that that argument misunderstands who Ms. Tucker is and what her capabilities are. Someone in Ms. Tucker's position with what the Social Security Administration defines as sub-average intellectual functioning, someone whose mental evaluation has found her to need extra accommodation, is going to be in a very different position when they are put in a witness stand and sworn in than your average person might be. And so I think the court has to consider that in light of who Ms. Tucker is and what she brought to the proceeding. I also want to be very clear about what happened in the trial court. And I'm reading here right from the record, and this is on page 13 of the sentencing hearing transcript, and this is the meat of this error, we believe. The defense counsel said, "Your Honor, I have discussed with Ms. Tucker any question as to call her as a witness at this hearing, and due to her unique circumstance, what we decided to do is Ms. Tucker has prepared an allocution that she would like to read to the court, and then I will be calling Ms. Tucker's sister to the stand." And that's what defense counsel said. An allocution presented in that context means an unsworn statement pursuant to the statute.
Did the trial court say, I'm not going to consider that unless she testifies?
And Your Honor, what the trial court said explicitly is, immediately after defense counsel said that, the trial court said she is going to have to testify if she is going to apply for diversion. That was exactly what the trial court said, and that was when the trial court said it. And that was as far as that issue went with the trial court.
So let me ask you this, and then your time is up unless there are other questions. But I ask you the same question I asked the state. From her allocution, however you want to phrase it, and compared to the actual testimony she gave under cross-examination, how much of that is crossover? How much of that is different, and how much of it went to or counted against her?
I understand I'm at the end of my time here. If you could give me just a couple of sentences, I think if I read you the allocution, that will help answer your question. It's a very short paragraph. And again, this is in the record. It was prepared on the back of a very small white paper bag. Your Honors will all see it. What Ms. Tucker read was, "To whom this may concern. First, I would like to express how sorry I am that the incident happened. I apologize for my actions to the court and to the young lady that I hurt. I regret that my anger got the best of me. I know that what I did was wrong, and could you please forgive me? I have been working on my anger problems and trying to learn how to walk away. I can promise that nothing like this will ever again happen, and that I am deeply sorry for what I did. Please accept my apology. I never meant for anything like this to ever happen. I will be attending my first anger management classes today, and please forgive me. I regret this ever happened. Sincerely, Yolanda Tucker." And what that allocution on its own would have shown to the trial court was someone who was deeply remorseful, who was credibly remorseful, and who had taken steps and was taking steps to address the problem that had led her to this court in the first place. Versus what the court witnessed, which was an intellectually disabled woman struggling to deal with cross-examination, struggling to deal with the stress of a situation that the law said she should not have been placed in. And so again, I would submit that that was an error for the trial court, and that taken on its own, the allocution would strongly have supported diversion. I submit that it still strongly does support diversion, and I am asking this court to reverse the trial court and to grant Ms. Tucker diversion on de novo review.
Yeah. I think we'll take the case under advisement, and we will stand in recess until the calling of the next case.
All right.